You know, you hear all sorts of stories about neighborhood disputes, but how does a simple garden planter, of all things, end up in a year-long legal showdown? Well, we're about to dive into a story that starts with some basic landscaping and ends up putting the very rules of community living on trial. So this is it. This is the decorative planter at the center of everything. But the real story here, it isn't about gardening aesthetics. Nope, it's about a much bigger question. What happens when the very system that's supposed to keep order just stops listening? It's a fight for the fundamental right to be heard. All right, so let's set the scene. We're in the Power Ranch community in Gilbert, Arizona. Homeowners Anh Jung and Aaron Solen wanted to do something simple, improve their front yard. They had no idea this one decision was about to send them down a year-and-a-half-long rabbit hole. At first, everything unfolds pretty much how you'd expect. The planter goes in, the HOA sends a notice, totally standard stuff. The homeowners in response submit a really detailed 15-page application. But then, on April 10th, boom, it's denied. And the reason? Something super vague, like not in line with community aesthetic. And it's that vague denial that really turns this from a simple disagreement into a full-blown legal puzzle. Because after that denial, any simple path to a resolution just vanished. From this moment on, the story basically splits in two. You have the homeowners on one side and the HOA on the other, and they start telling completely different, totally contradictory versions of what happened next. So from the homeowner's perspective, this was just a journey of pure frustration. Anh Jung testified that she tried over and over again to get a hearing with the board to just talk it out. She even modified the planter, tried to show them the changes, but she just felt like she was being ignored. And then, out of nowhere, they start getting hit with $100 fines every 2 weeks. For her, the crucial point was feeling completely shut out of the process. But, and there's always a but, the HOA saw this completely differently. Their attorney argued that they were actually trying to help, to be flexible, to guide the homeowners to a solution. In their version of the story, all the homeowners needed to do was follow one simple instruction. Just resubmit the application for the modified planter. That's it. That's all it would have taken. And this leads us to the absolute heart of the case, the one moment where everything pivots, a meeting that was supposed to happen on June 26, 2023. The HOA says this was the official hearing. The homeowners, they swear they weren't even there. So what really happened? Now, to really get the confusion here, we have to talk about what an executive session is. It's not a regular open meeting. It's a closed-door, private session where the board discusses sensitive stuff. And while they can invite a homeowner in to talk about their specific issue, the term itself screams private. So when the homeowners got an email saying their planter was on the executive session agenda, they testified that they didn't think that was an invitation to a formal open hearing. And this slide, wow, this just captures the whole contradiction perfectly. On one side, you've got the official HOA minutes. They say the homeowners were there, they spoke, end of story. On the other side, you have Anh Jung's sworn testimony in court. We never attended. I was not there. At all. I mean, it's a total impasse. You have a written record versus a sworn statement. Somebody has to be wrong. So let's trace exactly how this one disputed meeting led directly to real money penalties. The HOA operates as if the meeting happened and instructions were given. But the homeowners, well, they think they're still waiting for a hearing, so they don't do anything. To the HOA, that looks like defiance. And so, on October 2nd, the fines start rolling in. Eventually, this whole mess lands right in front of an administrative law judge. His job was basically to cut through all the noise, look at both stories, and decide on one core question. Was the homeowner's legal right to be heard actually violated? And the judge's findings were incredibly clear. He concluded that yes, the homeowner's right to a hearing was not granted. He pointed out that even if the HOA was trying to be helpful, that doesn't count as fulfilling their legal duty. He specifically called out the June 26th executive session, saying it wasn't a proper hearing because of all the confusion. And the bottom line? The HOA broke the law by finding them without giving them a clear chance to be heard first. So that sounds like a total win for the homeowner, right? Case closed? Well, not so fast. The judge's ruling was like a surgical strike. It was very specific, very narrow. And it led to an outcome that, surprisingly left nobody really happy. Let's break it down with the scorecard because it's fascinating. The homeowners won big on the procedure. The judge said the HOA messed up and he ordered them to pay back the filing fee. But on everything else, the stuff that actually matters day to day, They lost. The judge said he had no legal power to erase the fines or force the HOA to approve the planter or make them change their rules. He could fix the broken process, but he couldn't fix the actual problem. And that really brings us to the ultimate kind of frustrating takeaway. And it's all summed up by this one number: 0. That's the number of forms the judge could make the homeowners fill out. It's the number of approvals he could force the HOA to give. The legal system corrected the process, but it couldn't actually solve the underlying problem. Everyone was left right back where they started. This whole case just leaves you with this massive question. In these communities that are governed by thick rule books, what happens when the process itself is the problem? This story proves you can win the legal fight over procedure but still be stuck in a total stalemate. It really makes you wonder, in the end, who holds the ultimate power, the homeowner or the process itself?